this is from chapter 7, and Judge Raul talks about why the judicial record is crucial. And the first one interests me the most. In a national milieu where where truth is elusive, these records are fact-based and have been vetted by disinterested courts abroad. So, if the question is violation of human rights, I think the chapter presents several cases where claimants have won, and courts actually enumerating forms of torture that were inflicted by the Marcos administration on dissidents and those who disagreed. And that is the value of, the value of the case is because it tells us after judicial proceedings what happened during Marcos's time. Okay, and the rest of the chapters where, as I explained earlier, demonstrates the overlap between two sets of cases: the human rights victims' claims and the recovery of ill-gotten wealth, and how those two collide, even at present, I think, if I'm not mistaken. And foreign litigation efforts in the United States, etc. But it's the first one really that interests me. And in my own research, in other words, I agree with Dean Pangalangan, because in my own research on this one is on Campo, on the Marcos burial case. You have literature that says law constructs a history that it wants to present as authoritative. Okay, law traffics the slippery terrain of memory, as different versions of past events are presented for authoritative judgment. In the production of judicial opinions, law reconstructs its own past, tracing out lines of precedent to their compelling conclusion. It is not true, as the court said, Supreme Court said in Ocampo, that this is purely a legal issue, because decision writing has the effect of writing history, has a way of presenting the truth, which I think is consistent with what Judge Raul is presenting. Judicial decisions are products of social memory. They are one of the many social institutions that produce social memory. What happened really in the past is something that you can discover upon reading a court decision. And this is why the law is an important instrument in struggles for recognition of different victims of past injustices, because law formalizes and legitimizes particular narratives of victimhood. The law turns private memories into public narratives. And this is why I think the US cases cited on human rights claimants is important, because their story is recorded. And this is just true for human rights victims. It's true for virtually all international tribunals where mass atrocities were committed. Those courts have an additional function of presenting what exactly happened so that we cannot deny it. And just to give an example on that is probably the most famous of these international tribunals, where we tried the Nazis for crimes against humanity. See, and in the Nuremberg trials were staged to satisfy the requirements of both principal judgment and historical tutelage. In other words, not only do you arrive at a judicial conclusion, but you use it to teach. You use it to teach history about what happened during the Second World War. The trials were called the greatest history seminar ever held in the history of the world, that will provide an authoritative and impartial record to which future historians may turn for truth. These trials are designed to show the world the facts of astonishing crimes and to demonstrate the power of law to reintroduce order into a space evacuated of legal and moral sense. Again, emphasizing my point about why a judicial record is important for truth. And it's astonishing because historical revisionism on what the Nazis did, I think, started, if not started, well, it's targeted Nazi war crimes. They are denying that any of that happened. They're denying that Hitler was that evil and that only his subordinates were responsible for all the atrocities, the death of 6 million Jews. So, on one hand, you've got the role of courts, the history writing function, and then attempts to revise or deny these atrocities from the other side. My view is judicial record stands in the way of revisionism. If properly executed, because as I said earlier, I've got a huge issue with the way the Supreme Court, our Supreme Court decided Ocampo versus Enriquez. I think the court abandoned its history writing function for political considerations, I guess. And that is why Mr. Marcos is now buried in the libingan ng mga bayan. But I also think local courts can be disinterested as well. And that is why we have Sandigan Bayan decisions finding government officials guilty of graft and corruption. So it is not a monopoly of foreign courts. Although the temptation to classify them as such is understandable, because they are disinterested in the sense that the parties are not, Americans. I mean, in other words, the progress against Mr. Marcos as a state works in part because they are American courts, not persuaded by things other than the rule of law. And we know this, that courts can malfunction in that sense, because this is just a way of describing Javeliano versus executive secretary, where the court's role in legitimizing the authoritarian regime becomes indispensable. So courts, while you can preserve the record of human rights violations, atrocities, can in fact be used the other way, to justify probably the worst way to ratify a constitution. It can violate every provision of the Constitution, but the Supreme Court can still say there's no longer any obstacle to the 1973 Constitution. I think it's a duty to remember history. In other words, to find out exactly what happened. And that means getting away from TikTok and actually reading legal historical material so we can be informed of what happened. And that's the contribution of this chapter, the book, I assume. But this chapter in particular, and that's the point. See? These efforts, curating these materials, informs the election discourse, because I find out that trolls tend to stop when you direct them to official documents proving the atrocities of the Marcos regime, because they can't answer it, they can't fight back. So of course, we have as academics an additional function of translating academic works like this into something useful, something that can be used by ordinary citizens. That didn't sound very nice. By other people from other disciplines. Yeah, right? Because let's face it, we're all excited about the way the materials are simplified to an extent, because it helps our work when inform the public about legal history. In fact, before I forget, I want to thank Judge Raul for writing this chapter, because it saves me the trouble of writing it myself. And like everyone else in the panel, I am going to assign this chapter, and probably the chapter on national territory, because it explains why the Constitution was written that way, right? Why the preamble is written that way, why it talks about rule of law, and why we had to strengthen the Bill of Rights, why we had to include the provisions of social justice, limitations on the power of the executive, so that they can have a context, students can have a context on why we changed the Constitution. And now my outline will be dotted with Judge Raul's work. Thank you.